Hey, everybody. How are you? First of all, for those who popped in about noon and thought, ooh, we're going to do it early, I want to apologize because I got the wrong time when I set up the StreamYard. So, for those of you who are looking at me and going, man, Lori, you look tired, that is the reason. I have so much to tell everybody. So, before we dive into the true crime part of it, I just have a gazillion things to tell you about what's going on in my life. So, first of all, the book. The book, I am down to the last probably day's worth of edits before it goes back to the publisher. We're still going to, I'm still going to attend Chad's trial and be updating my manuscript and the chat and adding chapters having to do with Chad's trial. So, but the bulk of the manuscript is going to go back to the publisher here in the next week or so. So I'm excited about that. So, that's done. For those of you who would love to be part of the book launch team, I'm already tired. That website is going to go live within the next day or so, and I'm going to send out a newsletter to all of my newsletter subscribers, as well as notices in our YouTube community page as soon as that site goes live. I was hoping we'd have it up and live tonight, but I had a few little changes that I wanted to make to it. So my great IT guy's working on that, and we will have that up and ready. So what is going to happen is if you go to that site and you sign up and you pre-order the book, the first 100 people who go and sign up are going to get an advanced digital copy of the book, which will basically be the manuscript, which I am going to send to my publisher here shortly. So you'll get that copy. And in return for the fact that you're going to get access to it early, we're asking you to post a review. Now, most of the review sites don't allow you to post your review until the day the book drops, which is September 3rd. So we're giving you a chance to read the book in advance and then drop your reviews. And we will be sending out reminders and letting everybody know what's going on. In addition to getting an advance copy of the book, I'm also going to be dropping exclusive coverage having to do with Chad's trial. And we're going to be offering a weekly sort of Zoom style call where we can just hang out and have a conversation. So all of that's going to be available to you. Plus, we will be sending customized, personalized, I will be sending personalized autographed book plates to each of you to put in your books when you get them. So look for that link to come out this week. Go to the link, sign up. It will be thegoodlori.com is going to be the website, and we'll get a link out to everybody once we're sure it's live. And that's going to be super fun. I'm looking forward to getting together with the folks that are involved, being able to do a little bit more one-on-one kind of conversations. And so it's going to be fun and exciting. CrimeCon is a mere, let me look it up here because I have a counter on my phone, is a mere 70 days away. CrimeCon in Nashville. For those of you who have been before, you know how much fun it is. For those of you who might be thinking about it because you maybe live in the area, please give it some consideration. Now, I know tickets are not inexpensive for CrimeCon, but they do solicit volunteers, and volunteers get a pass. So if you look in our show notes, you will find links to CrimeCon and to the volunteer page. And as far as I know, they are still looking for volunteers. So consider that if it feels like the ticket might be out of your budget. So the big news for us, we didn't have a show 2 weeks in a row, and the culprit was me being on the road, um, looking at new homes in the Bend area. Now, for those of you who don't know me really well, I'll just give you a little bit of background. I lived in Bend, Oregon for 20 years. That was the primary place I practiced law. I was a public defender there. And I raised my only child, daughter, there. And when I retired and we moved, my goal was to spend some time places where we didn't have snow and get my feet on the ground as an author. So we moved to Mesa, Arizona, and we were there for 3 years. Then things just, with COVID and everything, things just sort of developed where it made some sense for me to move to Idaho, to be closer, to move to Boise, Idaho, to be closer to the Vallow case. So for the last 2 years, I've been living in Boise, Idaho, while the Daybell case has played out. But we also knew that those moves were probably going to be temporary, because I really wanted to be closer to my daughter, especially if and when grandbabies started showing up, because I'd like to be that grandma, you know? So my daughter announced a month or so ago that she and her husband, who both work in advertising, and it appears are both going to be able to work remotely permanently, decided that they wanted to move back to her hometown, Bend. So we went to Bend. Our daughter flew in from LA along with our son-in-law's parents, who we're very close to. And we all went shopping for homes. So the morning that we were ready to leave, which was last Wednesday, and I'm listening to podcasts on the way back, and I've got everything all planned out, and I'm thinking, okay, I'm going to get home in time to do a couple of hours of additional prep and be able to do our show on Wednesday. That was the plan, because we were supposed to be leaving out of town, dropping our family off at the airport at 6, and then hightailing it out of town. However, the night before, our friendly realtor, who has been our realtor on every home transaction in the Bend area for 20 years, dropped a house in our portal, and it was really interesting. So we delayed getting out of town so that we could take a look at this house, and it really was amazing. And so it really was everything we were hoping for. And so we then drove home. It was interesting. We took 2 cars over to Bend so that the rest of the family could have a car. So we drove back separately, and we got home, and my husband walked in the door and said, "I've been thinking about it." And I said, "I've been thinking about it." And by the time we were done, we decided to get in touch with our realtor and make an offer. So that is moving apace. The offer was accepted. We're moving through all of the stuff that you have to do when you buy a house. And we're also sort of getting through putting our Idaho house on the market. So it's all happening all at the same time. But that's kind of the way I roll. So thank you for your patience in the last 2 weeks. I missed you all, missed doing the show. And we do have a tremendous amount of things to talk about. So first of all, I want to talk about Daybell, because that is coming up. Chad's trial starts in 2 weeks. We have seen on the church on my mind, on the court website, that a transport order was entered that says that Chad is to be transported no later than the 22nd. So Friday, right? Friday. the last time when Lori was transported over here, a couple of law enforcement vehicles drove her from Rexburg to Boise, which is about a 5-hour drive, and delivered her to Ada County. So I'm assuming that's what'll happen with Chad as well. So there are a few new things on the court's website. Interestingly enough, or not surprising, I guess you'd all say, is that most of it is sealed. So we kind of have to read the tea leaves and figure out a little bit what's going on with the sealed documents. So first of all, there was a lengthy evidence stipulation. Now, when we talk about how court works, and y'all know this because you watch true crime court live streams all the time, but generally what happens is, let's say you have a piece of evidence, you have cell phone records, you have to lay the foundation, meaning that you have to explain how they were collected, who collected them, make sure that they were collected in the ordinary course of business, they're considered business records. You have to do all of that to overcome hearsay objections and to get the evidence in and make sure that the judge admits it. So the alternative to that is to agree with the other side to stipulate to what evidence is going to come in. If the other side says, yeah, just let's get all this evidence in, then you don't have to go through those hoops of laying all the foundation, bringing in the witnesses, bringing in the person who did the cell phone analysis and having them explain how they keep their records and all of that. So it really saves an awful lot of time and shortcuts some of that really tedious testimony that isn't really necessary, because when the jury looks at that information, they're going to be looking at the substance of that information. What do those cell phone records say about what happened around this place or this time? So the jury doesn't really care about who collected them, how they were collected, who downloaded the phone, under what conditions it was downloaded. But that's all information that has to be presented in order to get them admitted in the first place. So John Pryor and Lindsay Blake and her team have reached agreements on several pages worth of trial exhibits. That's going to streamline this process. But even streamlining it, I think we're still looking at 8 to 10 weeks of trial. Remember, this is still a death penalty case. So John Pryor is going to be dotting every I and crossing every T. In addition, there's going to be if Chad Daybell, I should say, if Chad Daybell is found guilty, there will be a penalty phase. And that penalty phase, whether or not to impose the death penalty, could take up to 2 weeks. So it's a good thing that they've reached those stipulations in evidence. The prosecution has also asked for the judge to simply bring back some of the trial exhibits that were in Lori's case. So there's one motion that says, Judge, rather than return all of those evidence exhibits to the state, we would like you to just roll them over into Chad's trial. So that's a possibility and will likely happen as well. So, but there are some really interesting motions which are sealed. So we have to sort of read in between the lines a little bit and see if we can figure out what's going on here. Now, because we know a lot already about the case, I think there are some things we can figure out. First of all, there's a motion to exclude a defense expert named Dr. James. James Davidson, Dr. Davidson. He is a local Boise forensic psychologist. My research is just what I could do on the web, and it appears that he's a pretty experienced forensic psychologist. So we don't know why the prosecution is asking to exclude him as a witness and to not allow him to testify. So that is one that's kind of interesting. The other motion is even more interesting. It is a motion to exclude Summer Shiflet's recording and to quash a subpoena for Rob Wood to appear as a witness. So to understand this, we need to go way back. We need to go all the way back to very early in this case, after the children's bodies were found, but before the murder charges were filed. Those of you who've been following the case a long time will probably remember that there was a recorded conversation between Summer Shiflet and Rob Wood. And now you're thinking, how did that happen? Well, here's the way it happened. Rob Wood went down to Arizona from Idaho and interviewed several people. He was there at the police station in Chandler when Summer and Zulema were both interviewed. Summer and Zulema were represented by the same attorney, Garrett Smith. He is also the same attorney that represented Melanie Pulowski, and he's the same attorney that Brandon Boudreaux sued and won a huge defamation suit against. He won $12 million in a defamation suit against those lawyers. But even at that, Garrett Smith was still in the courtroom with Zulema when she testified at Lori's trial. So really interesting. However, you got to go back to the summer or maybe early fall of 2020. So right after the kids' bodies were found. Rob Wood went to Arizona and he was at the Chandler Police Department when they interviewed both Summer and Zulema. Summer's attorney, Garrett Smith, recorded that conversation that Rob Wood had with Summer. And there were some interesting things in it. There were some discussions about relative culpability, who they had better evidence against, Chad or Lori, which I think is what John Pryor is wanting to get in, as well as some other conversations about the case. So John Pryor wants to present that, and the state and the problem is that he's got to get past a hearsay exception by laying a foundation. And the way he does that is he calls in one of the people who was privy to the conversation. Now, he's not calling in Summer, but the prosecution probably will call Summer again because it may call Summer again, let's put it that way. But John Pryor wants somebody to come in and lay the foundation for that recording. So he subpoenaed Rob Wood. Now, what we know from many conversations we've had on this channel, and especially around this case, is that an attorney who is representing someone in a case cannot come and be a witness in that case. So if an attorney is subpoenaed and forced to appear and testify, they have to withdraw from the case. So here we have this really interesting development because John Pryor has subpoenaed Rob Wood. Now, the state has filed a motion to quash that subpoena, meaning get rid of it, squash it. And they have filed a motion to exclude that recording from Summer. So the question is, if the judge quashes the subpoena against Rob Wood, how does he get that recording in? Or is the judge going to say, no, you can't bring the recording in at all? So those motions were filed, and everyone asked for an expedited hearing. There was an in-chambers super secret hearing held on March 8th, but we don't know what the results were of that because no orders, the court didn't make any orders afterwards. So we don't know what happened. If the court made any orders as a result of that hearing, they've been sealed. So we don't exactly know what is going on. But we do know that John Pryor he's certainly been much more aggressive than Lori's attorneys were. He says he's got 7 or 8 witnesses he's calling. He's got expert witnesses he's calling. And it's very clear that he's operating on a more assertive platform than Lori's attorneys were. I don't think that comes as any surprise. We've seen John Pryor for years in this case. And so I don't think it comes as a tremendous surprise that he approaches things differently than Archibald and Thomas did. And, it's important to remember as well that Lori really limited what information could be brought in by her attorneys by saying she did not want to use her mental health as a defense, and clearly by saying that she didn't want him blaming Chad or Alex. I don't think we're going to see that here. I think Chad and his attorney are going to toss Lori firmly under the bus at every turn. So it is definitely going to be a more vigorous defense. And that's going to make it interesting. The last thing that the state is trying to exclude, and this seems odd, is the introduction of a statement by Tammy Daybell. And we don't know what that statement is. Of all of the discovery that we have seen, we have not seen a statement from Tammy Daybell. We heard about the statements that she made around the incident with what she thought was a paintball gun and was really Alex taking a shot at her. But we don't really know if there's a statement connected to that, or whether there is some other statement that the public doesn't know about. That will be interesting to flesh out as the trial goes on. Statements of people who are dead are a little tricky to get in. So it may be that the state is trying to make a hearsay objection. We don't know. And that's another thing that was considered in this last hearing and was sealed. So we don't really know yet. The state has asked for a special counsel, attorney general, assistant attorney general to be appointed. This is kind of an interesting move. If you remember early on, the previous Fremont County District Attorney, Marsha Murdoch, it's not Marsha. Oh, yep. Anyway, she originally was the DA at the time that Tammy Daybell's death was being investigated. So she was still the DA at the time that they filed a motion to have Tammy's remains exhumed and the autopsy done. That was all done on her on her watch. But she had announced that she was not running for re-election, and her assistant, DA, was going to run for election. And Lindsay Blake came in. She was a hometown girl and mounted a really impressive campaign and won to be the Fremont County DA. So at the time that Marcia Murdoch was still on the case, she turned the Tammy Daybell case over to the state AG's office because she felt Fremont County did not have the resources to fully investigate the case. And it wasn't until Lindsay Blake took over and until the children's bodies were found that Lindsay Blake took the case back from the AG's office, from the state AG's office. So now they're asking for help from the state AG. So Madison County hired Rachel Smith and paid for Rachel Smith to come in as an additional attorney on the case. She was an experienced death penalty attorney. She was had experience in complex litigation. She is a consultant from Missouri, so she was admitted pro hac vice, which means just for this case. And after Lori Vallow's case was over, she asked to be relieved of that assignment, and she left the team. She then was approached by Canyon County, Idaho, and asked to join that very small rural DA's office to help them with the prosecution of Jeremy Best, who is our latest kind of high-profile case. He is the fellow who, it's very clear, had a mental breakdown and broke into his ex's home and murdered her, and she was pregnant with his child, and then took the almost 2-year-old little boy and was missing with him for quite a while. When officials found him, he was sleeping naked in a sleeping bag next to the road in the middle of winter, and the little boy was deceased in the truck. So he's got trial coming up very shortly, and Rachel Smith has been added to that prosecution team. Now Lindsay Blake has requested assistance from the AG's office, and I'm sure they will get somebody to come alongside and help them through the trial. Lori has filed, as y'all remember, she's filed a notice of appeal in her Idaho case. Now, what happens when you file a notice of appeal is that there has to be a written transcript of the trial created, and that's created by a court transcriptionist. And that is a very deep, labor-intensive kind of a job. Usually it's 2 people, one who goes back and double checks what the first one did to make sure everything is accurate. And it can take a very long time. So they have asked for a couple of different extensions on their time. The latest extension will be up on the 17th of April. So we might anticipate them asking for an additional extension, but they may be finished and may be able to go forward and get that transcript off to the appellate court. Once that happens, the clock starts running for the appellants that Lori Vallow and her team, her appellate lawyer, will then need to draft their opening brief. And they're very specific the way an opening brief is written. It has page limits, and there are very specific things that have to happen. So they will submit that, and then the state will have a specific amount of time to respond and have a response brief. At some point, then the court can make a decision. Are they going to ask for oral argument on the issues, or are they going to simply affirm it without oral argument, basically on the briefs? So that may be happening, but we'll wait to see what how that plays out. We've heard that I have heard now. I know people who are in the Rexburg area and have been very kindly letting me know sort of what the temperature is in Rexburg, and sort of, I mean, the emotional temperature, not the real temperature. I can tell you it's been cold there. But sort of, keeping me up on the vibe in Rexburg and Fremont County, St. Anthony. And so I hear little bits and pieces of things. So one of the things I've heard is that there is an issue. There's been sort of an issue around evidence, and it may have to do with Zulema. So keep your ears peeled here, and we will see whether that materializes or not. I do see a question in the chat, and I'm going to answer it right now. Will they start jury selection on April 1st? Actually, my understanding is that the judge wants to start jury selection the week before April 1st. I think they would very much like to start on April 1st. Jury selection may run over into that, but I think jury questionnaires they've settled on jury questionnaires. Those are going to go out in advance of with jury subpoenas, and then people will start turning those in, and they'll go through them, and then I think you will see jurors start being brought in the week before for questioning as a panel, and then individual questioning. Judge Boyce has issued an order this time, although it is nothing different than what happened last time. I don't recall whether or not he actually issued a court order about this last time or not, but he did this time, having to do with the process, jury and jury procedures, and permitting the court to do some of the jury questioning in private. That is not at all unusual. We really want jurors to be honest and forthcoming about their life experiences and about their opinions about things. That's harder to do when people are being questioned in public. So it's not at all unusual for the court to close at least some portion of jury selection to give the jurors privacy, meaning that they can answer questions. And there certainly are going to be questions about religious affiliation, religious beliefs, in addition to asking people what they know about the case already. So that jury selection process is going to go on. Probably the bulk of it will go on the week before the trial. It may spill over into the first week of trial. But I would look to see opening statements no later than Wednesday, which would be the 3rd. So that's a good question. And at this point, They did some of that in Lori's trial, but I definitely think that they are applying the lessons that they learned in Lori's trial as they're going forward. So I am going to be attending some of the days of the trial, but I have to tell you, since it's being live streamed, I may very well be at home packing boxes. We'll see. And we will just see as that goes along. I do want to remind you that if you are going to sign up for our book launch team, that I am going to be doing some special updates for folks who are part of the book launch team. So I'm going to be doing a lot of updates from Chad's trial. They're going to be directed at you all who sign up for the launch team. And I am going to do my utmost very best to get that link and that notice out to everyone by the middle of this week. And, or I'm sorry, by Friday, since today is the middle of the week. We are going to try and get that out to everybody. It will go out in a mass newsletter, as well as on our YouTube community page and our Friends of the Good Lori Facebook group. So we'll get that notice out. The link will be out. And I know there's lots of folks who've commented and asked how do we sign up? And we're going to get that information out to you as soon as we can. I'm super excited. I'm very proud of the book, and I'm really excited to give you all a sneak peek. So that is coming up. So I have some other cases I want to talk about. One of them is Madeline Soto. This is an incredibly sad case. I want to warn you all, this is a case that's going to require that we be a little frank about some sensitive issues. So I really want to caution you. Trigger warning that this might not be the segment for you if you are at all sensitive to the issues of child SA. Okay. So here's what we know. We know that Madeline Soto's mother, and we're not sure whether this guy was a stepfather or whether he was a boyfriend. He was either a stepfather or a long-term boyfriend. Mom goes to the middle school to pick up Madeline, who is 12. Just had her 12th birthday. Goes to the middle school to pick up Madeline, and she is not there. Mom goes into the school and says, I'm looking for Madeline. And the school says, Madeline never came to school today. Oh dear. So mom gets in touch with the authorities. She reports Madeline missing. The police come out, talk to mom, talk to stepdad. Everyone is in a panic because Madeline has not been seen since stepdad/boyfriend dropped her off at school. However, he says, I dropped her off a couple of blocks from the school because she said she wanted me to, and she wanted to walk to school because she's embarrassed about my car. So that was the story. So the search is on for Madeline, and a couple of days later, Madeline's body is recovered. As is standard procedure in any kind of a case, the family gets a hard look. And one of the things that happens is they seize stepdad's telephone. And they are able to recover off of stepdad's telephone recordings of him abusing Madeline since she was 8 years old. And so he has been charged. They also have video from the apartment complex where they lived that shows his car driving into the parking lot. It appears that Madeline is in the passenger seat. The police believe that she was already deceased at that point. No one really knows whether mother was complicit in any way in the case or whether this is purely a stepfather bad guy, whether or not mom covered it up. No one knows yet. So, evil stepdad was arrested because of the material that was found on his phone. He has been charged and has a trial coming up in pretty short order on the speedy trial because he's in jail. In the meantime, they're still investigating Madeline's death and waiting for results, investigation results, autopsies, those sorts of things. He has not been charged yet. But I anticipate he is going to be charged with murder in her death, and it's likely that the other charges will wrap up into that when it's filed. But right now, they've got a little bit of time to do the investigation, and they have him in jail. So as we've seen in these cases before, as we saw in the Vallow case, I mean, Lori and Chad were in jail for the better part of 2 years by the time the grand jury was able to convene, thanks to COVID, and they were finally indicted for the murder charges. So I don't think they're in a big hurry to charge him. There were a lot of people that were pretty upset with the fact that he hadn't been charged with Madeline's death. I think he will be in pretty short order, and I think they are just getting their ducks in a row. So, but it's an awful case. It raises so many questions, so many concerns, so many issues of how does a single mom trust someone and date someone around her child? Did Madeline ever make any disclosures? Was this a case where Madeline got to the age where she said, I'm not doing that anymore, and he got scared and killed her? I don't know. But all of those things are very possible in these sorts of cases. So it's a terrible case. I'm going to continue to follow it and continue to chat about it. I'm going to try and keep it as tender and as respectful as we can be, respectful to Madeline and also respectful to my audience and what they're interested in, as opposed to getting too deeply into details that are disturbing. So we're gonna stay on that one now. The next thing I want to talk about is the Delphi shit show. The beat goes on. Now, I'm going to tell you, if you want a deep dive into the nuances of all of these filings and what has been going on in Delphi, please, please, please follow Bob Motta at Defense Diaries. We've got a link in our show notes. He and his wife, Allie, they're both lawyers, both criminal defense lawyers. Bob has sort of left practice to do true crime full time. Allie is still practicing, and they're an amazing duo when you get them together. They're both really smart, and they're in Illinois, so they're just next door to Indiana. Bob has been going to Indiana for the hearings every time one happens. He will be attending the trial. This is another one that very likely will not be live streamed. The judge initially allowed cameras for one single hearing, and it was the hearing that didn't happen because she disqualified the lawyers. So that went up to the Supreme Court. The lawyers were reinstated, and Richard Allen has a trial coming up in like 58 days. So it's going to be absolutely fascinating. In advance of trial, there are motions flying back and forth like you wouldn't believe. Now, those of you who are familiar with the case know that at one point there was a leak of crime scene photos. It was awful. One of the two lawyers had a guy who was a former employee of his, was a lawyer who and had worked in this guy's office, dropped by one day to chat. And while the attorney was on the phone and the guy was waiting for him, he went into the conference room and saw that all the Delphi discovery was laid out on the conference table and snapped pictures of some of the crime scene photos. He then shared them with someone else. That person sent them to 2 or 3 true crime creators who promptly sent them back to law enforcement and contacted law enforcement. The person who snapped the pictures was charged and is facing criminal charges as a result. The second person in line actually took his own life when police started questioning him about it. So, I mean, it was an awful situation, not anything that could have been anticipated by either one of the lawyers. However, after Judge Gull disqualified them and the Supreme Court reinstated them, because the Supreme Court said Judge Gull didn't have the right to do that and to deny Richard Allen his chosen attorneys that he had a relationship with, the prosecutor in the case filed a contempt of court action saying he wanted them held in contempt for the leak. Now, contempt of court is something that occurs much more often in civil cases than in criminal cases. And there are a couple of different kinds of contempt. There's a civil contempt and a criminal contempt. So the prosecutor, who is not very well versed in the laws and the rules around contempt, has filed essentially a defective action. And Richard Allen's attorneys, Baldwin and Rosie, have retained an attorney who has filed pleadings saying this is a no-go. In spite of that, Judge Gull, who is decidedly pro-prosecution and hates Baldwin and Rosie, set a hearing on the contempt issue. So on Monday, there was a hearing on the contempt, and Bob Motta, Defense Diaries, has got a great rundown on what happened. He was there, and the judge took it under advisement and said she was going to issue a ruling. She then allowed them to file some written closing arguments. And the way that the schedule works out, those won't even be to her until sometime in May, and she's reserved 30 days to make a decision. So there's no way a decision is going to be made before Richard Allen's trial, which means it's not going to interfere in any way with his counsel. So they're gearing up for trial. There are a number of other motions. They filed a motion because the law enforcement lost or was interviews that were overwritten during the first 70 days of the investigation. Apparently, they had some sort of a malfunction with their equipment, and because of that, the videos in the interview rooms in the police station overwrote the interviews that they had conducted, having to do with potential suspects early in the case, who are the people who the defense has identified as potential suspects. And they're all people sort of involved tangentially with this whole idea of Odinism. So Baldwin and Rosie have filed subpoenas. Now they notices of deposition. They want to take the depositions of several people. And now Nick McClelland, who is the prosecutor, is objecting to that, even though it's probably going to be people, the information could potentially be exculpatory for Richard Allen. There's also, so the defense filed a motion to dismiss the case based on this mishandling of evidence. I don't believe Judge Gull is going to do that. I think she's going to say you have written summary reports of the interviews, and that's good enough. But I also don't think that she's going to limit them taking depositions from some of those folks as well. And so it will be very interesting. There's also, as we've talked about before, some dispute about the bullet that was found at the crime scene. According to the defense attorneys, it was found sort of buried in the leaf litter between the two girls at the crime scene. And it actually was found later. The crime scene was cleared, and then they went back and they found it like 6 days later. So there's a lot of questions about that bullet. Was it there the day of the crime scene? Was it there? Was it all there at all? What was the chain of custody? How did that happen? Who found it? And then on top of that, we have the issue of the scientific issue. And as we've talked about before, some facets of ballistic are more reliable than others. And there's a real move in the defense bar to challenge ballistics as junk science. So one of the things that is not exceedingly reliable are the pattern of ejector pattern. So very quickly, when you put a bullet in a gun, the mechanism, you have bullets in a magazine. So you have more than one bullet lined up to put in the chamber. So you rack the gun, you put a bullet in the chamber. Now let's say that you fire that bullet. Well, the lead propellant, the lead shot, the bullet comes out of the rifle barrel, and then the spent shell, the cartridge, is ejected out of the gun. I'm not a gun expert, but I do know this much. And so you have two different things to look at. You have this lead projectile, and you can look at that and you can see the striations and the marks on that bullet, and you can compare them with the inside of the barrel. Now, barrels have rifling on the inside of them because that helps the bullet come out straight. They also, every time you fire a bullet through a rifle or a handgun, the barrel is scratched, scraped, marked, and that leaves marks on that lead projectile. So the barrel of a gun can be very, very identifiable. It can be very unique. And so the markings on a bullet are a lot more reliable when it comes to comparing ballistics. However, if you don't fire that bullet and it's in the chamber and you tell the gun, I want to eject that bullet without firing it, then there is a mechanism that pulls the bullet out and ejects it. That mechanism is much less reliable on the way that it marks a cartridge, because and it's much easier to come up with a gun with a similar type and caliber of gun and get similar ejection marks. Hopefully that makes sense. So it's less scientifically reliable, those ejection marks. So what the prosecution has said is that bullet worked through Richard Allen's gun. Okay, it's a bullet of the right caliber, and And it shows these ejection marks that prove it was worked through a gun that was owned by Richard Allen. However, there are thousands of that make and model of gun, and it could very well be that scientifically you can show that a similar gun would have made similar ejection marks. So that is going to be a hotly contested issue as that trial goes forward. The judge did not rule on either motion, on the motion to dismiss or the motion for contempt. She is going to issue a decision fairly quickly on the motion to dismiss. I do not anticipate that she's going to grant that motion to dismiss. The prosecution is asking to limit the people who can be deposed. I don't think she's going to do that either. But this case continues to just be incomprehensible in so many ways. For instance, Judge Gull ordered not only that there not be cameras in the courtroom for this most recent hearing this week, but she also ordered that there would be no written transcripts. So news agencies can't order a written transcript. This is because she had a court reporter in her chambers when she decided to disqualify Rosie and Baldwin. And people got a copy of that transcript, and it was not a good look for her. And it made her look bad. And so now she is not allowing any transcripts of court proceedings. And that is crazy. How in the world, if you can't get a court transcript, do you appeal this case? Do you appeal any of the rulings that happened during that hearing? You can't, because you can't get a transcript. So it will be really interesting to see how this goes forward. It is very clear that Judge Gull is in the tank for the prosecution, that she hates Baldwin and Rosie. And, you know, Bob Motta made a really good point. You never want to do something as a lawyer that is going to disenfranchise your client. You never want to put your client in the position of a judge disliking you so much she's going to take it out on your client. And so it's always a really fine line. Richard Allen wants them, he trusts them, they believe in him, and they are really zealously advocating for him. But that zealous advocacy has meant that they've gotten sideways with the trial judge. And there's a point that you have to ask yourself, am I doing a disservice to my client because this judge hates me so much that it begins to compromise my client's right to due process? I don't think that Baldwin and Rosie are there, but I think that it's a question that lawyers always ask themselves when you get into that situation. So that will be, I think that will be a question continuing as this trial goes on. Bob Motta says that he is going to attend the trial. There are several other people who will be attending the trial as well, so we should get some good feedback back. But it is distressing that we are likely not going to get any information directly through the court. Now, we saw in Ballard Daybell that the judge didn't allow cameras, but he did allow the release of the recordings at the end, at the close of each court day. There's a possibility she might do that, but right now she's got that courtroom locked down. And if you're not there, you are not going to hear what's going on. So we have one small update on Adelson. Donna Adelson has a trial date, which happens to be September 30th. So we will be covering that. I hope by then I'll be moved, or we'll be covering it from Bend, but we'll be covering that. And it'll be very interesting to see how that trial goes, particularly since there are an awful lot of people that would very much like to see Wendy Adelson charged as well. So, and I do want to talk about a couple of other cases, and I definitely want to talk about the Karen Reed case, and then we'll take some questions. A couple of really quick updates. One has to do with Chad Dorman. So those of you who remember last summer, it was a horrible. We saw the police body cam of Chad Dorman being arrested, and he is accused of having executed his 3 little boys. He was arrested, and we all saw that. He was sitting on his front porch with his gun next to him. His wife tried to interfere. She was shot through the hand. His stepdaughter ran across the street to the fire department and alerted people to what was going on. It was horrific. Well, he was taken into custody, charged with murder, and now his attorneys filed a challenge to the confession, and the court actually threw out his confession and found that the police did not properly give him his Miranda cautions before he was questioned and confessed. Now, does that mean he walks? No. Because there are too many other witnesses. There are 2 eyewitnesses who saw what happened. So I don't think that there's any danger that Chad Dorman's going to walk out a free man. I think he has severe mental health issues. I think his attorneys have had him in mental health evaluations, and there may very well be other motions coming up having to do with his competency and with his mental health at the time the crimes were committed. However, I do think that it's a setback for the prosecution, because now they're going to have to really put together a lot of those eyewitness reports as the most compelling information, where when you are introducing a confession, you have to have corroboration for the confession. It can't simply be, my guy said he's guilty. The law enforcement also has to present evidence that corroborates the confession. So what they would have put on as the corroboration of the confession now has become the direct evidence that will be presented by the prosecution to prove the crime. So, but I don't think there's any risk at all that without the confession he walks. So there's just too much other information, and we don't know what he said after he received his Miranda cautions. We don't know that. So there may be additional information that he gave law enforcement after the Miranda warnings were given. The other case is Corey Richens. Corey Richens is the woman out of Utah who is accused of murdering her husband by lacing his evening cocktail with fentanyl. And she's also the mom who wrote a book, a children's book on grief about for her children after her husband's death. And there's an interesting little twist to that one. You may remember that there was some discussion about the fact that she was communicating with her mother and her brother and attempting to get them to say things that probably weren't true. She was communicating directly with them and asking them to tell law enforcement XYZ. One of them was she wanted her brother to tell police that that her husband had been going to Mexico and bringing back drugs, which wasn't true, other than that he brought back marijuana edibles. So the interesting twist is that that mom that she was communicating with, her name is Lisa Darden, is now under investigation for potentially poisoning her partner, her romantic partner, in 2006, and collecting a big life insurance policy as a result. So interesting, and maybe the apple doesn't fall far from the tree, eh? So we'll keep an eye on that. Lastly, I want to talk about Karen Reed. First of all, I want to tell you that if you are interested in this case, and it is another one, it and Delphi are probably the two biggest twisted shit shows lately that we have. If you are at all interested in a deep dive, please follow Brandy Churchwell. She does a YouTube show. She also has a podcast called The 13th Juror. And she has done a deep dive into this case called Conspiracy in Camden, I think. And so here's the thing. This is a small town right outside Boston. And the victim was a police officer. And all of his friends were police officers. And he was going to a party at a police officer's house when the prosecution alleges his longtime girlfriend, Karen Reed, dropped him off at this house party and then backed up and hit him as she was leaving. And he died in the snow outside of this house. It was terrible weather, terrible blizzard, and he died of both his injuries and hypothermia. What makes this case so interesting is that there is a huge segment of the true crime community that believes that Karen Reed is innocent and has been set up by the police, because John O'Keefe, the victim, was a good friend of a bunch of police officers and was at a police officer's home. What the defense alleges is that John O'Keefe had a conflict with the son of one of the people that was at the party, and that when he went into the house, they got into an argument and somebody beat him very badly and threw him out in the yard where he died. And they then made it look like Karen Reed had backed into him as she was leaving. There are so many inconsistencies in this case, so many things that don't add up. The evidence just doesn't add up. It doesn't gel, to the point where the defense asked the feds to get involved and investigate whether or not there was police corruption and whether or not there was a cover-up. The feds issued a report. Their coroner said these injuries could not have been caused by the injuries to John O'Keefe's body could not have been caused by backing into him. And the damage to the car could not have been caused by the body that he examined. So it's super fascinating because this case is twisted and there are so many inconsistencies. Then to top it off, there are a couple of YouTube creators, including a guy called Turtle Boy, who have gotten very involved in the case. In fact, Turtle Boy has gotten involved and has been with the crowd protesting Karen Reed's innocence outside the courtroom, to the point that he's been arrested and he's being accused of witness tampering for harassing witnesses going in and out of the courthouse. He's also being accused of somehow colluding with Karen Reed to intimidate witnesses. So it is a crazy case. It is coming up for trial very soon, and I will be following that one as well. It has been live streamed, and I expect it will continue to be live streamed. I'm sure that Brandy Churchwell will probably have the live stream on her YouTube channel. Brandy Churchill's podcast, the audio only podcast. The link to that is in our show notes. And she also does a YouTube channel, and she is very deep into this. She got interested in true crime thanks to the Murdaugh case. She is one of those people who creates spreadsheets and timelines and combs through documents. She's super, super detail oriented. She posts all that stuff on a website. So if you're into that, take a look, because she does a really, really good job. So that is all I want to go through tonight, but I'm sure that you guys probably have a ton of questions. So let's take some questions. I'll give Jen a minute to catch up with me. Ta-da! Hi, LA. I suspect typical answer, but I want to ask a question. Why don't people just plead guilty more often? And why not more often strategic ask for bench trials? These are both really good questions. And this is a great way to start off our Q&A session. So in reality, about 95 to 98% of cases settle, plead out in criminal cases. That's because the police do their jobs. They do their jobs right. They gather up the evidence, and the evidence is overwhelming, and the person pleads guilty. Prosecutors often will lay out the evidence and say, we'll make you a deal and you can plead to a lesser charge, or we'll recommend probation, and people do mostly plead. So it's only in these very complex cases that we see people not pleading guilty. The other thing is, if it is a murder and if the prosecution is seeking the death penalty, then the person who the defendant has no reason to plead guilty, because the stakes are too high. They have to go to trial. So generally, if the prosecution has offered some sort of non-death penalty deal, then potentially somebody could plead guilty in a murder case in order to avoid the death penalty. But in states where the death penalty is pursued zealously, like Idaho, it's unlikely that the prosecution is going to offer something less than the death penalty. And if they do, it's kind of surprising. So I don't think that if they don't offer something less than the death penalty, then there's no reason not to go to trial. So that's why we're seeing trials in those cases. And your other question, why not more often ask for bench trials? So that's a tough question. If you have, as a lawyer, what I think about when I think about whether or not to ask for a jury or to have a judge hear the case, One of the things is, what does my client look like? If I have a sympathetic client, a client who I think would do well in front of a jury, who um, a jury might find sympathetic, then I think a jury is a good call. However, if I have a client that's not real likable, or that has a criminal history that is not going to play well with a jury, then I'm going to talk to my client very earnestly about waiving jury and having a judge decide, because judges are ethically required to be as unbiased as is humanly possible. They are by nature and by training going to weigh both sides. And so I think it is, there are times that I have said, I would never, that's a good question, Jen, and I'll answer it in just a second. There have been times when I have said, you don't want to go in front of a jury. And there have certainly been times that I have looked at jury outcomes and thought, I would never want to be judged by a jury of my peers. I would much rather have a judge who really understands the law, who really understands how to apply law to facts to make a decision. So, um, so that's some of the reason. Uh, Yes, judges tend to be more law-based and juries tend to be more emotional, because juries don't have the training that lawyers and judges have, because judges are lawyers, um, to apply law to fact in a more objective way, in a less emotional way. And so sometimes it's hard for juries to sort out that I have this emotional response to these facts that I've heard. But if I coldly and calculatingly look at the elements of the crime that the prosecution had to prove, did the prosecution prove that did the facts the prosecution presented prove those elements beyond a reasonable doubt? So that's the piece that I think you run the risk with a jury, um, that they're not going to fully understand. Um, and so sometimes we do get juries that are operating from their emotion, and judges are much more likely to understand that you have to apply the law to the facts and determine whether they proved all of the elements of the crime beyond a reasonable doubt. And I think sometimes that's a little bit harder to explain or teach a jury. Jen asks, what's the difference between a judge and a magistrate? So this varies a little bit from state to state, but in general, in states where they have a differentiation, it's kind of like a hierarchy of judges. So at the lowest level, you have the court referees. They usually hear some juvenile cases. They often hear landlord-tenant cases. They hear low-level stuff that's just sort of above small claims. And then you have magistrates. And typically magistrates hear what we would think of as misdemeanors. So things that are punishable by less than a year in jail, less than a $6,000, $6,500 fine. And generally magistrates also do things like issue Family Abuse Prevention Act restraining orders, elder abuse restraining orders, and sometimes do a lot of landlord-tenant evictions and those sorts of things. And in Idaho, that's the way things work. So in Idaho, a magistrate does a lot of the routine stuff. So in Lori Vallow's case, what happened was Judge Farron Eddins, who was the magistrate, heard the initial reading of the indictments and the initial arraignments and bail hearings and some of the preliminary stuff having to do with Daybell. Once the indictments were filed and they had been arraigned on the indictments, it had to be kicked up to a judge. And in Idaho, that means the magistrate handles misdemeanors and lower civil cases with lower damages. And circuit court judges then hear felonies and big ticket civil cases. And so in the Vallow Daybell case, Judge Boyce had been the magistrate in Fremont County. And when the judge who had been the circuit court judge was elevated to the Supreme Court, Judge Boyce was appointed to fill that vacancy. So he had only just been appointed as a circuit court judge in 2019. And then, of course, COVID hit and courts shut down. And so he didn't have a tremendous amount of higher level experience in trials. He certainly had trial experience because he'd been a magistrate and he'd been overseeing misdemeanors and those kind of cases for a while. So, but that's a good question. It does vary a little bit from state to state. Some states have referees, some states have magistrates, some states have, my home state of Oregon used to have district court judges and circuit court judges. And district court judges were basically a magistrate, the same job that a magistrate does in Idaho. And Oregon did away with that system and made all of its judges circuit court judges probably 15 years ago. So they do still use referees to do juvenile delinquency, the lower level juvenile delinquency cases. So the everyday, graffiti, tagging, those sort of cases. The more serious, what would be considered felony juvenile cases are generally tried by a circuit court judge in Oregon. So, and unfortunately, most of those cases get remanded to adult court anyway, if the kid's over 15 or over. Hi, Tennis Girl. Do you think Chad's trial will start on time, or what do you think could cause the delay? I think Chad's trial will start on time. It may delay in taking testimony into the next week because it may take them longer to seat a jury. Like I say, they're going to start jury selection the week before April 1st. Actually, jury subpoenas are going to go out. They may go out this week, actually, with jury questionnaires. Jurors are going to be asked to return those questionnaires to the courthouse. And at that point, they'll be given a day to return for jury interviews. So what they'll do is they'll go through those jury questionnaires. They'll see if there's any that are, obvious disqualifications. And then they'll have the jurors come in and they start by filling up the jury box and asking sort of group questions. They then will go to questioning each individual juror, and they'll do that in private. As we said, Judge Boyce has issued an order having to do with jury selection. So that's a lengthy process, depending on how many people they disqualify. It could take a while to get a jury that everyone agrees are folks that are non-biased. Then there'll be challenges, and they will come down to the final 12 plus another 6 alternates, I think is what they had last time. So last time in Lori's trial, they didn't use any alternates, but we will see what happens. But it's always good to have a number of alternates. If you recall, in the Murdoch case, they got down to only having one before they finally finished the trial. So, and you don't want to get in a situation where you're losing jurors in a lengthy trial. So they will start that jury selection the week before. That selection might run over into the week of April 1st, but I think we'll see opening statements sometime that week, could be maybe Wednesday. And the judge, of course, has to read and charge the jury. They swear in the jury. They read them all their introductory instructions, and then opening statements. So maybe Wednesday. But we'll see. I mean, a lot of it's just going to depend on how long it takes to seat the jury. I don't believe at this point there are any other issues that are going to delay Chad's trial. I think that ship has sailed. And everything I have heard is that there were some plea negotiations that went back and forth, and they were not able to reach agreement. And as far as any of the players go, the prosecution or the defense, I think it's going to be full steam ahead. And I don't believe that Judge Boyce is going to put up with any delays. He was very unhappy about the fact that Lori's trial had to be delayed from January to April last year because of the discovery issues, or actually it was delayed because of her mental health evaluation on that one. And he was pretty upset about that because he had made all the arrangements with Ada County. Ada County is accommodating the trial, and it is a huge undertaking for them. And he was very upset with having to reschedule that trial for April because of the inconvenience it was to Ada County. So I don't see him delaying that trial at all. I think he is set on being a good guest in the Ada County Courthouse, and I think that he is pretty adamant that that trial is going to go forward. So, good questions. Hi, Arizona. What do I think of Summer Shiflett presenting at CrimeCon? Isn't that interesting? You know, I had not heard that, but I hadn't looked at the most recent CrimeCon email I just got. That is interesting. Kay and Larry presented at CrimeCon the year before in Las Vegas. They actually presented and were joined by Nate Eaton. So I don't think it's all that unusual. I don't even know whether she will be a witness in Chad's trial. So remember that Summer came, and her testimony was to lay the foundation to get in the jail conversation that she had with Lori, and to play that for the jury. And that was very emotionally moving and very important to the jury. I think they got a real sense of Lori's lack of remorse through that conversation. So, but I don't even know what Chad's defense could be wanting to call Summer for, other than that recording. And it appears that they're trying to call Rob Wood to lay the foundation for that recording. And, you know, Pryor's not dumb. He knows that would mean that Rob Wood would have to be disqualified. So that certainly would put the prosecution team at a disadvantage. So I'll have to double check. Like I say, I haven't seen that because I've been kind of busy with a lot of other stuff. I saw the email come in, but I admit I didn't click on it. Will Lori Vallow have access to Chad's court filings? Yep. Once both trials are done, she will have access to everything. Her attorney and her team will have access to everything. And, you know, in general, I don't know that it will raise appellate issues, but it could. I mean, it could in some kind of narrow circumstances, they could say, or information information could come up that they could say is new information that wasn't available to them, and to try and justify a new trial that way. So yeah, that information will all be available. Oh, LA, you are so welcome. I understand that we have a lot of listeners from outside the US, and our laws are different. And remember that because we have that pesky 14th Amendment to the Constitution that gives states sovereignty, the rules and the rights vary from state to state sometimes. So at this point, we have about 28 states, I believe, right now that still have the death penalty, and but the rest of them have abandoned using the death penalty. There are a couple of states, like my home state of Oregon, that we still have the death penalty. However, our outgoing governor from 2 years ago, as she was leaving office, commuted the sentences of all of the people who were on death row at the time. Her predecessor had put a moratorium on executions because of the complications and the difficulty in getting the drugs necessary to carry out lethal injection executions. And so the moratorium had been going on for almost 10 years. When she left office, she then commuted all of the sentences in Oregon. So no one in Oregon is currently on death row, but it doesn't keep prosecutors in the individual counties from seeking death penalty in murder cases, in aggravated murder cases. So that'll be a little interesting to see how that's going to play out. There's another interesting thing that's happened in my state, my home state, and that is that about a year and a half or 2 years ago, Oregon put a measure on the ballot, because they do a lot of legislation by referendum in Oregon, put a measure on the ballot that was passed that decriminalized drug possession. And the idea was to stop prosecuting these low-level drug offenses and funnel that money into treatments and rework the drug policy so that we're encouraging people to go to treatment and not continue to use. And the prisons are full of people who are drug addicted. And treatment in prison is not great. So it was a great idea. What the state of Oregon didn't really anticipate was this tidal wave of fentanyl that was coming into the United States. And I think although Oregon was seeing its share of fentanyl overdose deaths, I don't know that at the time that legislation was, that referendum was voted on and approved, anyone really understood how that was going to impact the overall opiate addictions, and so Oregon has now walked back. Oregon's legislature has now walked back some of those changes, and is intending to recriminalize some drug offenses, but still will treat them more like a traffic citation, with with an assurance that they will be dismissed if the person participates in drug treatment. So they're trying to be as progressive and as forward thinking as they can about drug treatment, while still trying to curb this terrible opiate crisis that's going on across the country. I think it was a good experiment. I think that's got some things to recommend it, but on the other hand, I really do understand how difficult it is without some sort of leverage to get people into treatment. One of the things that I did hear has come up, for those of you who follow these kind of things, there's been a movement recently to allow the use of psychedelic drugs. So psilocybin mushrooms, LSD, ketamine, some of those drugs for the treatment of mental health. And there is ample proof that the use of those psychedelic drugs often helps and can give lasting relief to people who have certain mental health conditions. So Oregon is one of the states, along I think with Colorado and perhaps California, that has been working to allow these psychedelic drugs to be decriminalized and to be used either in microdosing or in clinical settings. And one of the complaints about the re-regulation in Oregon is that it includes the psychedelic drugs that have never been proven to be addictive and have now proven to be extremely beneficial for some mental health conditions. So I hope the Oregon legislature will be working through that and make what they're doing a little bit more nuanced than just completely recriminalizing all of the drugs that are on the schedules. So that was a little bit of a digression, but here we are. Do we have other questions? Do you have thoughts about Rust's trial and what it might mean for Baldwin's trial? Thanks, Tennis Girl. Yeah, I think the questions, the legal questions are interesting because they really kind of go back to causation. So there's a chain of events, and that chain of events causes an outcome. In that case, you have to go back and look at who was responsible in order to figure out who was negligent. Hopefully that makes sense. Because in order to be found negligent, you have to have a duty to do something and not do it. So in the case of Hannah Gutierrez Reed, who was the armorer, she clearly had a duty to teach people how to handle guns properly, to check the guns, to assure that the ammunition was dummy, and to check and to double check. And it's very clear that those checks and double checks were not done. It's very clear that it is more likely than not that Hannah Gutierrez was the person who brought the live rounds onto the set. Live ammunition should never have been on that set. It was. And it's very likely that Hannah Gutierrez Reed was responsible for that. The question is, did Alec Baldwin have a responsibility that he neglected? So if the typical sequence is Hannah Gutierrez takes the gun, shows it to the second director, and they check the gun together, the second director then takes the gun and says, "Cold gun," and hands it to Alec Baldwin. Does Alec Baldwin have a responsibility to then take that gun and check it himself? I think that's the question that is going to have to be answered. One of the questions is, does he have a heightened responsibility because he was also a producer on the movie? I don't know that that is the case. I don't know that producer duties give you a heightened responsibility to check a gun when you are blocking a scene as an actor. So that really is going to be the question. I don't think there's any question that Hannah Gutierrez had a duty to assure that that gun was safe. She had a duty not to bring live rounds on the set. She had a duty to check every one of those rounds to be sure they weren't live. She had a duty to check that gun with the second director. Now, what she did was she flipped it open and she showed it to him. She didn't necessarily spin the cylinder, and it's not clear whether the second director really got a close look at the ammunition that was loaded in that gun. There are also other questions about one of the armorers who testified at Hannah Gutierrez's trial said, I would never put dummies in a gun unless it was a scene where those bullets were going to show. I understand why you put dummies in a gun belt. I understand why you put dummies in a gun if somebody's going to flip the cylinder open and you're going to see that it's loaded. But in a gun that's being used as a prop and is not going to be shown that way, there's no reason to put dummies in it anyway. Yet Hannah Gutierrez put dummies in the gun, showed it to the second director. The second director didn't look at it very closely. She didn't spin the cylinder. They closed up the gun. Second director says, cold gun to Alec Baldwin and hands it to him. Alec Baldwin then is pulling the gun out. Now, there certainly is testimony that Alec Baldwin liked to have the gun in his hand when he was blocking a set. He didn't want to. He wanted to know what that. He was pulling it out of a holster. He wanted to know what that motion was going to be like with the weight of the gun. Okay, actors have quirks, and that's probably not all that unreasonable a thing for an actor to do. But the question is, did Alec Baldwin have a duty to check that gun? Now, most people who are familiar with guns and handle guns would say every person who gets a gun in their hand has a duty to make sure that gun is safe. And so every person who handled that gun should have opened it and made sure that it was safe. I don't know that that is a legal duty. I mean, I think people would say out of an abundance of caution, I would always check a gun. But that I don't know is, it falls into the category of a legal duty. So that one is going to be really interesting to see what a jury does with that. And I could certainly understand how a jury could find both ways for Alec Baldwin. I think that the case was pretty clear cut for Hannah Gutierrez Reed. I think that she had a duty clear cut. She had a contractual duty. She was contracted by the production company to be the armorer. She had a contractual as well as a legal duty to make sure the guns were safe. And it was very obvious in the testimony and the videos that were played that she was not a good armorer, that she was not good at keeping firearm safety on the set in general. So Looper says actors aren't expected to check the gun per SAG safety protocols, I think I read. That wouldn't surprise me. That would not surprise me at all. Because I think no one assumes that actors are going to be gun handlers. And many actors don't have any experience with guns. I mean, the testimony in Hannah Gutierrez's trial showed that, brought that out. There were many people who said, no, I'm not a gun person. I don't have any experience with guns. The only experience I've had with guns is the training I got from Hannah on the set. So, good questions. Hi, Tiff. Oh, you almost made me spit my water through my nose. Yeah, if Judge Gull, this is the judge in the Delphi case, wants to appear unbiased. Shouldn't she run her courtroom as transparently as possible? Well, you would think, wouldn't you? But Judge Gull, from the very beginning, has said, my way or the highway, and we'll do it my way. She got smacked down by the Supreme Court, but the Supreme Court also did not disqualify her. And so, yeah, she's going to run that courtroom the way she wants to. And she has very clearly transmitted her, has telegraphed her bias over and over again. And it's sad because I'm not convinced Richard Allen is guilty. I know that there are a lot of people who are, and that's fine. I am not convinced, but I have not seen all the evidence. All I've seen is what the public has seen. And based on that, I think the prosecution's case is pretty weak. I'm not convinced that Richard Allen is guilty. That means that the guilty people are still out there. And but the sad part about it is I think that Judge Gull is very biased for the prosecution, and she dislikes the defense attorneys. And I think that is going to end up with Richard Allen being convicted and this going up on appeal forever. And that would be tragic. If Richard Allen is not guilty, it would be a tragedy for him to be convicted and have to go through years of appeals to be exonerated. So we'll see what happens. I don't have any confidence at all in Judge Gull. I think that she's in the tank for the prosecution. I think that on top of that, on top of her prosecutorial bias, she also despises the defense attorneys, and that is a recipe for disaster. So I think the only thing that saves Richard Allen is some really, really good lawyering on the part of the defense and a good jury. And I'm going to keep my fingers crossed that they're able to seat a reasonable jury that will actually look at whether or not there's reasonable doubt. So, good question. Now, don't make me blow my water out my nose. Hi, Lily B. How can the state deny Richard Allen funds for experts and his attorneys? Couldn't this be a reason for an appeal if he's found guilty? Absolutely. And this is Judge Gull. She keeps turning down their funding requests. The way that public defense is funded varies from state to state. So in some states, there is a state office, a state organization that oversees the expenditures for public defense. And in that regard, in that way, like my home state, we would file a request for an expert, and we would say, I need this expert. It's so much an hour. Here's what I estimate. And then the state would either approve or deny. But that was a state agency. It wasn't the judge. In Oregon, if you had a problem with the state agency approving, you could go to the judge and get a court order, but that was very unusual. But you didn't have to go to the judge to get an approval for expenditures. But in some states, the judge is the person who approves the expenditures, and it is that way in Indiana. So when the attorneys that Judge Gull hates ask for money for experts, she has been either slow walking them or not approving them. And she's also been doing that with their compensation. So they are having to submit their bills and ask for payment, and she is slow walking or disapproving their compensation as well. I mean, you know, to be honest, it's shitty and it's petty, and it will have an impact on Richard Allen's right to a fair trial and his right to due process. If she continues to deny those experts and deny those requests. So I mean, I don't know. I don't know how this woman gets away with it. I mean, when I heard that she had said there will be no transcripts of Monday's hearing, I mean, I was like, I I was texting Bob Mata and saying, "What the hell?" Or something even worse than that, I think. So yeah, it is really, really hard to wrap your mind around that. So, you guys got some great questions tonight. LA, are you surprised no one is pro bono human rights violation litigation for Richard Allen for advertising or fame? I'm not, uh, I guess I'm not surprised. I wouldn't be surprised if someone came alongside as a human to bring suit for human rights violations. But remember that in this context, he's got two good lawyers, and they have filed motion after motion of safekeeping motions, motions to move him, motions to, and they have fallen on deaf ears because they've gone in front of Judge Gull. Any other motions would go in front of Judge Gull too. And so I think probably if there are going to be human rights uh, uh, kinds of suits brought, it's going to be post-trial, because then they're going to have all the ammunition to line up to say this judge was biased from the get-go, and here's all the reasons why. So, and you know, not attorneys really don't take on high visibility cases for the most part. I would say they don't necessarily take them on for advertising or fame. You know, a lot of lawyers take on those kind of cases pro bono because they're righteous cases. And, you know, I certainly think Richard Allen's case falls into that category. I think that he's been wronged. And I mean, even if it is shown that he is guilty of the murders of Abby and Libby, his treatment pre-trial, I think, has been abysmal. And even if he were guilty, I think there are human rights violations that could come because of his pretrial treatment. So I think it's a good question, and I wouldn't be surprised to see somebody step up and help him, but I think it'll be post-trial. Oh, good question. Hi, Jenny. Meow, meow. Lori and Chad are permitted limited contact, or are they no contact? So right after Lori's conviction and her sentencing, the prosecution asked the court to clarify that there was no longer a no contact provision between them. And the court said there's no longer an order of no contact. So they are allowed contact. Now, what that contact looks at like sort of depends on the Fremont County Jail and the Maricopa County Jail, where Lori is now in Arizona. It depends upon what she's been able to, what sort of contact she's allowed under her pretrial detainer. So it's interesting that when she was checked into the Maricopa County Jail, she showed up with a tablet and a computer, a laptop. The laptop very conspicuously said property of means law. So apparently he gave that to her. But she showed up with a tablet and a laptop, and they took those from her. So I don't know what sort of access she has now in the Arizona and Maricopa County. I suspect it's less than she had in the women's prison in Idaho. So I don't know what the rules are for her as well, for how much contact she can have with him, or vice versa with Fremont County, what sort of contact he can have with her. However, I thought it was interesting that the prosecution wanted to clarify that, because I think they would be happy to have them talking on the telephone, because I think they feel that there would be some disclosures between them that might be made accidentally. So, but they are now allowed contact. I'd be very surprised if she's not writing to him all the time. I will say that hi Blaze. Let me add this little aside here before I answer that question. I will say that a little birdie told me that Chad Daybell has pictures of his children and Tammy in his cell, but there are no pictures of Lori. So that was an interesting little tidbit to get. Blaze, why don't they use fentanyl as the drug for use in the death penalty? Well, good question. All of the laws that allow execution by lethal injection allow a specific cocktail of drugs as the preferred or mandated method of lethal injection. I suppose that state legislatures could change those laws to allow for the administration of other sorts of substances. However, the thorny part of it is that the manufacturers of these chemicals, as states call them rather than drugs, the manufacturers of these drugs are the ones who have said we will not sell to states for the purpose of using them for lethal injection. They were created and designed to be therapeutic and to be used to treat illness. They were not designed to end life. And I understand that when you have a medical profession who has sworn a Hippocratic oath, first do no harm, it is difficult to use those drugs that have been developed by medical people for the use and treatment of illness to be used to end someone's life. And that has been their stance. So if the state were to get legal fentanyl, I think they would probably run into the same issue. The biggest problem with fentanyl right now is all the illegal stuff coming across the border out of Mexico, and that it is being laced into street drugs where people are taking them and taking fentanyl unawares. So it's being laced into cocaine, it's being laced into heroin, it's even being laced into marijuana. And that is frightening because a person who thinks that they're taking a certain dose of heroin ends up taking an overdose of fentanyl unknowingly. And that's happening a lot. So good questions. Well, we are coming up on the end of our 2-hour block, and I am thrilled that I got the opportunity to visit with you tonight. I want you to know I missed our time together. Oh, don't forget, on our website, and there is a link to download to make a crane square for a quilt for Larry and Kay Woodcock. The pattern it's a paper piece pattern. The pattern is on the website. I promised I was going to make a how-to video. Haven't done it yet. I am so sorry. Just been snowed with so many other things. But the size of the block is 6 inches. And the pattern, the downloaded pattern that I put on for people to download, it finishes to a 6-inch block. If you look at it printed on it, it says you have option for a 6-inch or an 8-inch, or I don't remember, but I specifically sized it on my printer and made a block and measured it to be sure that you were creating a 6-inch block. So that's, if you print it as it is, as you download it, it should be right and make a 6-inch block. I will, once I get all of the blocks, I'm going to put them together with sashing between the blocks, so you don't have to do any of that. And then I'll add a border, depending on the colors of the blocks. And all we're asking is that you use a black background fabric. Any black will do. Even some black on black patterns, if you've got those, just make sure that the background's black. You can use any color, any pattern for the actual crane, because the more colorful and the more interesting, the better. So I'm just encouraging you to go through your scrap bag and find some fun fabric that you can use for that. It doesn't take very long to make the block. You probably can make one in less than an hour. And then you can drop them in the mail to me. The address is in our show notes. It's the same address that you send to if you want wristbands. So I still have plenty of wristbands. I'm going to take them to CrimeCon and hand them out as swag. I also have some fun stickers and some fun stuff to hand out at CrimeCon. And I'll be handing out book plates to anybody who can show that they've pre-ordered the book. And for those who sign up for the book launch team, one of the things you'll get is a personalized and autographed book plate for your book. So look for that link to come out in the next few days, and so you can join up for the book launch team. So I just want to say thanks again tonight. Thanks to Jen, who is our moderator and keeps things moving along tickety-boo. She also is the admin for our Good Lori Facebook group. So if you're not a member there, please drop in. I'm sure that I will be posting many more things as Chad Daybell's trial gets underway. I'll be trying to be busy on Twitter or X or whatever we're calling it these days, as well as our Facebook group. But if you sign up for the book launch team, you will be getting exclusive messages from his trial. So thanks again, everybody, for joining us. Thanks for your patience and all the nice messages I got saying that I was missed in the last 2 weeks. And one of my followers, who has become a good friend here in Boise, said to me, well, actually, we were at Chad's trial. You guys are all get a kick out of this, and then I'll wrap up. We were at Lori's trial, and a break came in the trial, and we were talking to some people who were standing around, and somebody walked up and said to this person, "How do you know the good Lori?" And before she could answer, because this woman had told me that she listens to our stream before she goes to bed at night, and sometimes she falls asleep. And so I looked at the other woman and I said, "Well, we sleep together. That's how we know each other." And I thought this poor woman was going to spit her teeth out. But so I will say tonight to Jane, good night, Jane. And to all my other people who listen on the re-listen crew. Please, if you have questions, comments, I do go through and read the chat. I usually have coffee the morning after and review the chat, and any comments that you leave below, please feel free to ask questions, to drop comments. If you're shy and you don't feel like you want to do it publicly, you can email me at info@thelorivallostory.com. That's all in our show notes. I'm going to say good night. Thank you, Jen, for all your help. And we will see you next week. I promise. Good night.